Hello, my name is Sarah Coderre, and I am an employment, human rights, and labor law lawyer at Bow River Law in Calgary. Today I'm going to answer the question, is my employer allowed to take away some of my sales territory? This is a common question among many salespeople, where primarily their income is earned by generating business from clients within a defined territory or geographical area. And so, of course, having that territory interfered with in any way or having it reduced or changed can have a direct impact on the clients they're allowed to service and, as a result, how much money they can make. An employer is allowed to make certain changes to the workplace, depending on business needs and challenges that may arise, as long as those changes are not to fundamental terms of an employee's employment, and as long as the changes are being made with appropriate notice and consent of the employee. So, considering whether or not an employer can take away some of your sales territory is going to really depend on what we're talking about here. If you've got a geographical scope or you've got 50 clients that are evenly distributed throughout, and the employer's taking away about 10% because they're looking at redistributing some of the workload to somebody who maybe doesn't have enough work, and they're taking sort of your bottom 10% of clients, and you don't expect it's going to have a significant impact on your ability to earn an income, then in that case, provided that your employer gives you notice in advance that this change is coming and helps you understand why the change is needed, and you agree to it, then yes, they can go ahead and do that. And it would not be considered to be a fundamental change in your employment. However, if your employer said to you that they were going to take 50% of your sales territory and give it away to somebody else, and in that 50% is all of your best clients, and you know that as a result of the territory changing, you are going to face a significant reduction in your income, you should certainly protest that change and let the employer know very clearly that you don't agree to it. And B, if the employer continues to move ahead with that change, despite the fact that it's going to have a significant impact on you, and despite the fact that you've clearly told them that you don't agree to that change, then that would land you in a position of being constructively dismissed from your employment, should you choose to view it that way. A constructive dismissal can occur where an employer changes a fundamental term of an employee's employment contract unilaterally, meaning they do it on their own without any consent or agreement by you, the employee. If you feel that your employer is making a change to your sales territory, that is a fundamental change that's substantial to your employment, that is going to have a significant impact on your ability to earn a living, and you've raised this issue with the employer and they continue to go ahead anyways, then you should absolutely reach out to an employment lawyer to understand, is this actually a constructive dismissal in your case? And if so, are there steps that you can take to deal with it? In some cases, having an employer be made aware of the legal implications of their business decisions can cause them to shift and change course, such that you maybe wouldn't have to leave your employment and be constructively dismissed, and the issue can be resolved. Unfortunately, in some cases, employers do know that what they're doing could result in a constructive dismissal, but the business imperative and reasons for doing it outweighs any sort of legal risks that they think they might face in their mind, and so they go ahead anyways. And in those cases, moving forward with an employment lawyer to assert your legal rights and ensure that you're getting proper compensation is a step that you should take. Thank you.